Seated. We welcome you to the June 18, 2025 setting, the Seventh Court of Appeals, sitting in the courtroom for the Fourth Court of Appeals in San Antonio. And I want to thank San Antonio for allowing us to use their courtroom. It's always a pleasure traveling down here. And if we can get Mr. Ramirez to work a little harder, maybe we can come down a little bit more often. But no, thank you for coming here. And I know some of the attorneys had to travel, all the attorneys had to travel here. So we appreciate that too. And hopefully I-35 wasn't too bad. With that, we'll go on and call the docket and give me your announcements. I think there may be, the appellants may have several counsels that want to present arguments. So give me your time split on that if you want to do that. And so we'll go from there. You have been informed that appellants get 20 minutes, appellees get 20 minutes, and then the appellants get an additional 5 minutes. So appellants, you don't have to reserve any time. You're going to get 5 minutes. With that said, the first case we have today is Don B. Meador, Karen Meador, Kimberly Dawn Place, trustee of the B.K. Edwards Water Trust and Maxwell Specialty Utility District. Yes, ma'am. Come on in. Or not. Okay. Maxwell Specialty Utility District versus Guadalupe-Blanco River Trust, a Texas nonprofit corporation. For the appellants.
Thank you, Chief Justice. My name is Ed McCarthy. I'm here on behalf of appellants Don and Karen Meador and the B.K. Edwards Trust, joined by Mr. Ian Davis on behalf of Maxwell Special Utility District. I will be presenting argument the first 15 minutes, and Mr. Davis will be presenting the last 5 minutes.
Okay.
And then I will be presenting the rebuttal argument.
And you understand that I'm not going to stop at 15 minutes. If he bleeds over into your time, that's it. Okay. So it's either you get there and tug on his coat, or you tackle him or something, but get him away from the podium if you want to talk. Okay.
Thank you, Your Honor. I will.
Okay. For the appellees.
David Blank, Your Honor, for the appellee GBRT. I'm joined by Jim Bradbury, various members of the board of GBRT, and I will be presenting argument for GBRT.
Very good. Very good. Appellants, Mr. McCarthy.
Thank you, Chief Justice Quinn, members of the court. My name is Ed McCarthy. I'm here on behalf of the appellants, the Meadors, and the B.K. Edwards Trust. This case involves the construction of an agricultural easement that the Meadors granted to the Guadalupe-Blanco River Trust in 2027. The Meadors own a piece of property, approximately 210 acres in Hays County, just above Spring Lake and the opening of the San Marcos Springs. It's known as the Dreamcatcher Ranch. It overlies a portion of the Edwards Aquifer here in Texas, and that aquifer is regulated by the Edwards Aquifer Authority. The Meadors have a permit from that authority for pumping rights. The Meadors own the groundwater and the surface of that 210-acre rights. The Edwards Aquifer Authority was validated in 1996 following the Supreme Court's ruling in the Barshop versus Medina County.
Question, if I may interrupt. You said that the Meadors own the water, correct?
Yes, Your Honor.
One of the debates, maybe tangential debates, is the effect of the permit. Does it transfer the water? I guess it's more than tangential. There's a permit. It was granted. Right now, the trust is receiving income because they're leasing the permit. Is that correct?
They're leasing the pumping rights under the permit.
Rights.
Yes, Your Honor.
Okay. So can the Meadors say, even though they've transferred the permit, you can't take any water?
From the ranch?
Yes.
If I was about to get into this, Your Honor, the Edwards Aquifer Authority and the rights and law related to it under the Edwards Aquifer Act is unique here in the state of Texas. It is the only governmental entity regulating groundwater in the way it regulates it.
Understand, but, and I understand that the argument is, well, you're not taking water from the ranch because we in effect drilled off the ranch and we're draining the ranch for that portion allowed by the permit. Before that was, the permit, so to speak, was leased. If the trust said, we want to drill on the ranch and pump water, could Meadors have said, no, you're not taking our water?
The trust has no right to drill or take water from the ranch under the agricultural easement, Your Honor. If I could take just a minute and back up and explain that. The agricultural easement is intended, and that's the key document that needs to be construed and looked at here, because it's the one that controls. The Meadors own the groundwater underneath their property still, even though they have leased the pumping rights. The pumping rights are the right to pump water from the Edwards Aquifer. It is.
Who has a permit right now?
Right now, the permit is partially in the Meadors and partially in the BK Edwards Trust.
Okay, the part that's in the BK Edwards Trust, could the BK Edwards Trust, if they did not lease that interest to a third party, the BK Edwards Trust wanted to invoke that, their portion of the permit, and pump water from the ranch, could they do that if the Meadors said no?
No, they could not if the Meadors said no.
So they have a right to pump water.
They do not. The Meadors have a right to pump water. The trust does not have a right to pump water from
Under
the
the
ranch.
permit, they wouldn't.
Correct.
Assuming they didn't, they weren't leasing their interest in it.
Correct.
Okay.
Even though they have leased some of the permit pumping rights, it doesn't give them the right to pump from the ranch. But even if they did pump from the ranch, depending upon what they did with that water, it would not violate the agricultural easement.
If they pump from the ranch, could Meadows say, no, you can't have the water?
Yes, Your Honor, they could.
Okay.
The Meadors own the water. Edwards Aquifer rights, which are based upon historic irrigation use, which is what the Meadors rights are based upon, were divided under the statute between what are known as base irrigation rights and unrestricted irrigation rights. The base and that was based upon the desire that there always be sufficient water to continue to cultivate and maintain the agricultural character of land that got irrigation rights on that basis. But there is also a provision under the law that allows base irrigation rights to be converted to unrestricted irrigation rights. And the policy basis for that is that the EAA was created because of concern about flows coming from the aquifer and coming out of Comal and San Marcos Springs to protect endangered species. And so the legislature capped the annual volume of water that could be pumped from the aquifer. And the aquifer that's regulated covers 8 counties from Uvalde to Comal County. And it services and provides the primary water resource for over 2.5 million Texans here in Central Texas. So the concept was, if you got an irrigation right based on historical irrigation, we want to keep some of that water with that land so you can continue to irrigate. So 1/2 of all of those rights was described as big or base irrigation and stays with that land. The property, it was permitted based upon unless it is converted. And if it is converted to unrestricted irrigation rights, then the pumping rights can be moved away from the land and used anywhere within the Edwards Aquifer Authority. That all requires formal filings with the Edwards Aquifer Authority and their approval. And that's a process that the Meadors followed. With respect to what the rights of the trust are, the trust has unrestricted irrigation pumping rights that it leases, and they only allow the lease use to be from property outside of the Tree Catcher Ranch. And the reason for that is that the ag easement speaks specifically to groundwater pumping at the ranch. It allows groundwater pumping on the ranch for the purposes of continuing to maintain the agricultural and ranching character of the ranch. It prohibits, with one exception, it prohibits pumping water from the property, from the 210 acres. That's very important. And taking it off that acreage and using it someplace else. That's not illegal. It's contractually prohibited by the ag easement. There is one exception to that, and that is that the Meadors, if they have leased contiguous property up to 50 acres for agricultural irrigation purposes, they can take and pump water from the wells on the Dreamcatcher Ranch and use it off the ranch within that 50 acres. But you cannot pump it from the ranch. And the reason for that is that you want to keep the water in the Edwards Aquifer and the surface water on the property, on the 210 acres that are described in the easement that is governing here. The pumping rights are
They
not.
really are not, because they're allowing it to be drained from a side parcel of property.
Your Honor, you're looking at 8 counties.
I understand, but they're allowing it to be drained from a side parcel of property.
The law allows, and the agricultural
We
easement
understand. I
does not
understand that.
prohibit.
I understand that, but you indicated, and correct me if I'm wrong, but I interpreted what you just said as like the state wanted to preserve the water on the ranch. So it'd be like them building a wall all the way down to the water table, through the water table, preserve the water. Well, that's not what is being done, because migration of water, like oil and gas, it migrates. So they can pump from the side, from off the ranch, and deplete a good portion of the water table. So it's not really true they're preserving all the water.
Your Honor, hydrogeologically, what you have just described is not quite accurate. One thing to keep in mind, not only does water migrate away from the ranch or migrate anywhere within the aquifer when it is pumped, but it migrates constantly. The Edwards Aquifer is almost characteristically the equivalent of an underground river the way it flows, going from west to east and coming out at San Marcos Springs and Comal Springs. The water that is under the ranch, and under Texas law, you don't have a right to the water under the ranch wherever that water is. You have a right to the water while it is under the ranch.
Right.
And so what we're really talking about is a distinction between the groundwater estate, which is a property right, and the pumping rights under the Edwards Aquifer permit, which is nothing more than a license authorizing the user to pump not only according to what the law says, but within the capped volume that the legislature could be pumped annually without harming the aquifer and without harming the species. If the intent of the easement had been to prohibit pumping elsewhere, it would have said so. What the ag easement does say is you can pump from the ranch. We can take it directly from out from underneath the ranch, the entire amount that was originally permitted, the 133 acres, and that's all right, but you have to use it on the ranch, okay? They specifically had that prohibition. They knew what they were contracting for. If they wanted to contract to prevent, because these pumping rights can be used anywhere from Uvalde to Comal County with the approval of the Edwards Aquifer Authority. It's a process because there's an accounting process. The EAA needs to know that.
Okay, and one of the issues here is whether or not there was a transfer of an interest in royalty.
Doesn't Evans cut against you on that? I know Evans is an old case. I mean, it's from the Texas Supreme Court from 1936, but the argument you're making right now, doesn't that confirm that it's an interest in real property?
No, Your Honor, it's nothing more than a license. The permit demonstrates that what you have done is complied with what the law requires in order to produce the water, the right to pump. This court addressed this question somewhat in the Berkeley versus Railroad Commission case, recognizing that it was nothing but a license, analogizing it to a driver's.
The case didn't talk about transferring a permit, did it?
No, it talked about a trespass with regard to whether the permit.
And so here we're talking about the effect of transferring a permit. So is it really on point?
It is with respect to what a permit is. A permit is not a property right, Your Honor. The property right is in the Edwards Aquifer, and the Meadors have not given up that property
And
right.
in Berkeley, did it talk about a permit to drill water?
No, it was an oil and gas. Okay.
And in Berkeley, did they have regulations indicating that this permit is appurtenant to the land?
No, but as a practical matter, the oil and gas drilling permit is pertinent to the land on which the well is going to be drilled. But the Edwards Aquifer regulations also have rules that specifically address the issue of unrestricted water and the ability to move that anywhere else. You are not moving the water right. The Meadors continue to own the water, even having leased the permit. They continue to own the water underneath their property. They have statutory rights with respect to continuing to use that permit for what are known as exempt uses that don't even require a permit. They own that water. Nothing
But they
has
cannot
changed.
Take out all the water that the permit originally allowed them to take, correct? Because they only own half of it now.
No, no. The half has to do with the pumping rights, not with the ownership of the water.
Can the Meador, when the Meadors obtained the original permit before they transferred it to the trust, how much water could they take out?
They could take out 133 acres for irrigation use.
How much can they take out now?
They can take out as much as they would be authorized for example.
133 acres.
I haven't done the math on that, Your Honor. They still have approximately 30 acre feet of pumping rights for non-exempt uses, and they have the exempt right. The statute specifically, the EAA Act specifically says that the ownership of the groundwater does not change based upon the pumping. The pumping permits were an artifact that were created for purposes of ensuring that there was a capped amount that was met every year.
If the Meadors sold their property to somebody else, would the right to obtain the water also go with the property? That's one of the sticks in the bundle that would be sold, right?
Yes, Your Honor. Justice Sauce, the groundwater estate would pass with the fee simple transfer of the property. Again, the pumping permit is something that is what you have to have in order to pump within the cap. There is nothing that precludes the Meadors or a subsequent owner from buying or leasing from the trust or buying or leasing pumping rights from any third party and moving them to their land.
If they sold the property to somebody else, the new buyer would take that subject to whatever conditions or restrictions were put on the land at the time, right?
Yes, Your Honor, including the agricultural easement. Critical here is nothing has changed under the agricultural easement with respect to the character. The leasing of these pumping rights has not deprived the ranch at all. The Meadors have made extreme investments on conservation in order to achieve that. I'm happy to continue to answer questions, but I'm at my 5 minutes and I'd like to give Mr. Davis a chance if I may.
Thank you.
Thank you.
Thank you. Thank you, and may it please the court. Justice Doss, I would like to address the Evans case that you brought up. I do not believe that cuts against this position. The Evans case involved a contract where the party bought the exclusive right to drill water. And explicit in that contract, it said you've got the right to come onto the surface estate to do that. And what the court there resolved was, does that create a property interest? And of course it does. The right to enter the surface estate is absolutely a property interest.
Well, I agree, but the court's opinion went further as to also, it wasn't just the right to enter the estate, it was also the right to take the water, right?
And here, there's no right, my client, Maxwell, has no right to take water from the Dreamcatcher Ranch. It has the pumping authorization. It's leasing that authorization from the trust to draw that water from property that is distinct from the Dreamcatcher Ranch. I would like, if I may, in my brief time, to address an alternative argument that is advanced by the appellants. And that is, if this court does conclude that these are real property interests.
Curious. Kind of, and again, if I'm wrong, please correct me. Kind of law of fixtures. You have personality. Generally, personality is not part of the royalty when you put it on royalty. Put a car on top of the land, it doesn't become part of the land. But if it's affixed to the land and it cannot be removed without major damage to the land, it becomes part of the land, correct? In a situation, is that situation analogous to this? You have a permit, and then you have to transfer 50% of that permit to a subsequent owner. At least with regard to that 50%, or that you have to transfer it. Does that mean somehow the permit has become affixed to a land in some way?
In a sense, Your Honor, I would quibble with the 50% because what the act says in the implementing regulations is that the BIG designation has to stay. And all of the Meador's BIG authorizations remain at the Dreamcatcher Ranch. It's about 29 or 30. Everything that my client is leasing is UIG unrestricted, which the regulations in the act say can be transferred. And as to the alternative argument, if I may very briefly discuss that, is the agricultural easement in the exceptions and reservations provision, it calls out at a minimum, the 66.6 UIG unrestricted rights that were granted in 2002. And so if this court does find that these are property interests, we believe that the final judgment should still be reversed. And it should make the distinction that the 66.6 acre feet that were explicitly called out in the exceptions and reservations provision, that our lease or the transfer of those does not breach the ag easement, but just the approximately 37 acre feet that were converted from BIG to UIG in July of 2017, that would breach the ag easement. So that judgment would make clear that my client can continue to lease those 66.6 acre feet, which again, were explicitly accepted and reserved in the ag easement and were UIG since 2002, the original permit. But that other 37, that would revert back to the Meadors and to the Dreamcatcher Ranch.
I want to try to pinpoint you. I just want to make sure I understand what you're saying. I don't have CR lights. I don't know how much time we've got, so I apologize. Where specifically are those rights called out in the reservations and exceptions?
Yes, Your Honor. It would be the clerk's record 451. That's Exhibit D to the agricultural easement.
What document is that?
The agricultural easement
That's the agricultural.
in the four corners of that document, Your Honor.
Okay.
And so again, that's strictly in the alternative, if this court concludes these are real property interests. But again, the chief argument here is that they are not. These are regulatory authorizations.
Was your alternative argument raised in front of the trial court?
It was, Your Honor. And again, these are regulatory authorizations. The groundwater estate remains with the Dreamcatcher Ranch. My time is concluded. Thank you.
Thank you.
May it please the court.
Mr. Blank, they have a right to pump. They really don't have a right to take anything because the Meadors own all the water?
I'm sorry, I apologize. I did not
It
hear.
seems like your opposing counsel is saying they have a right to pump subsequent transferees of the permit, but they don't have a right to take anything because the Meadors really own all the water.
Your Honor, if I might explain, you used the analogy before of this being like a fixture or a wall built around the property. And in a sense, that's exactly the case when the conservation easement was put in place. Under the statute, under the EAA Act, Edwards Aquifer Authority Act, which really ought to be the starting point here for any analysis of what's the nature of this right. Under that act, it tells us that Section 1.34 that except as otherwise provided by this section, a permit holder may lease permitted water rights, but a holder of a permit for irrigation use may not lease more than 50% of those irrigation rights initially permitted. The user's remaining water rights must be used in accordance with the original permit and must pass with a transfer of the land. So, Your Honor, what we have in place here is the original state of these rights when the conservation easement was put into place under section 1.34 is that all of these rights were pertinent to the land. They were tied to the land at the time that this easement was
Is
put
that
into
the real
place.
issue? If
It
it's
re-
pertinent, the answer is one thing. If they're not a pertinent, the answer is something else.
Correct, Your Honor. And as this makes clear, at the time that the easement was put into place, 100% of them are pertinent. And then there's allowance made under the statute, not under the conservation easement, but under the statute about how 50% may be devoted to something else. But originally, everything 100% is pertinent to the land.
The appellants are spending time talking about the language of the permit, not necessarily about the EAA. In the event that there's a conflict, and I'm not saying there is, but in the event that there's a conflict between the permits language and the EAA, do we ignore the permit? Do we say, well, that's what the permit says, so the state is bound by it, or what do we do there?
Your Honor, I am unaware of any area where either side has made a claim that the permit in some fashion is contravening the act itself. So I don't foresee any conflict of that sort where you need to wrestle one versus the other. I think it's clear enough under the act. Again, 100% of these rights were pertinent to the act. Of course, then the EAA also has rulemaking authority, and it's 71195A. This is Rule 71195A. The EAA's rules say base irrigation groundwater and unrestricted irrigation groundwater. So we're hitting the waterfront here, both of those of an initial regular permit. So again, we're getting back to the original state of these water rights are pertinent to the historically irrigated land, period. That's the historically irrigated land here with the Meador's property, Dreamcatcher Ranch. By rule and by the original EAA Act, it's clear these rights were tied to or pertinent to Dreamcatcher Ranch.
Is anybody arguing that either the rule is unenforceable or that portion of the act is unenforceable?
There's been no argument, Your Honor, that the act is unconstitutional, ultra virus, anything of the sort. In like manner, there's been no contention by either party that the rules promulgated by the EAA were somehow ultra virus or at odds with state law.
So if you were correct, would that rebut the alternate argument proposed by opposing counsel that the most that the court could take back was the part transferred under the big?
66.6 acres.
Your Honor, I don't see that as actually tied to the alternative argument, at least as I understand it. The alternative argument is essentially a construction of the conservation easement itself. And all it says is these are the exceptions to title, and it lists off various things. There's no mention of carving out 66.6 acre feet or any portion of these permitted water rights there. I think fairly read what this exceptions provides is there's this regulatory process under the EAA Act that has displaced the rule of capture. Normally in a groundwater situation, you can stick a straw in the land and take as much as you want. And that's an exception to title here because you don't have the rule of capture. You have the police power having taken force and limited what would otherwise be a groundwater owner's property rights here. And that's all that's being done with these exceptions.
Well,
It's
I
not-
asked opposing counsel just a minute ago. I said specifically, we're talking about rights being called out on the limitations and exceptions position or section. And he said that there are those rights that are being discussed in Exhibit D.
Yep, Your Honor, it's simply an attachment to this conservation easement, and these are listed as exceptions to title. Look at Exhibit D. These are exceptions to title. And there's nothing about the 66.6 acres reserving or accepting or anything of it other than an exception to title, Your Honor. And so there's nothing of the sort that can fairly be construed out of the conservation easement that gives them that right to those, that portion of the permit. Now, this argument about the Evans case, Evans is, the appellants are correct here, Evans, and there are other cases like it, where it's a contract case. And there was a contract right there that was construed and determined to be an interest in real property. And all we're saying, Your Honor, is there's nothing in the statute itself that makes these statutorily created rights of any lesser dignity than what was previously found in the contract setting. The EAA is granting these permit rights, and just like having a contract right would be an interest in real property, the statute itself is making these an interest in real property. Under section 1.34 does that by making clear it's all part and parcel of the property as it's originally permitted. And the same is done under section 711.95A, making clear that these both kinds of irrigation rights, unrestricted and base irrigation, that are granted in the original permit are pertinent to the land. So in the same way that in Evans, those rights were pertinent to the land, these permit rights are equally pertinent to the land. So these rights are not of any lesser dignity than the contract rights construed in the Evans case. Chief Justice, you brought up the Berkeley case, and it's certainly the case in the oil and gas context that the Supreme Court have looked at various of these permits in that context and likened them to law licenses, restaurant operating licenses, and things of that sort. If you look to the regulatory scheme itself, that's what defines the nature of the right. And here again, section 1.34 makes it clear that these rights are pertinent as originally permitted, are pertinent to the land. It makes it clear how they can be transferred to some extent, 50%. Not that that's consistent with the conservation easement, but just under the regulatory scheme itself, 50% of them would be transferable at that point, Your Honor. And then by rule makes it equally clear that these are pertinent to the land. So very much different than the Berkeley case or
In the oil and gas setting, in the permits there, do the regulations talk about it pertinent with regard to permit?
and none of the cases talk in those terms. There's nothing like that in the statutory scheme. As a matter of fact, to the extent there's any discussion, it's that the Railroad Commission is not obligated to look at issues of title or property or anything like that, that those, if there's some dispute about that, can be decided by some court, that they're simply looking exclusively at the conservation laws and things of that sort. Will drilling in this manner that you're proposing be consistent with or contrary to these various conservation laws? And there being no such issue in those cases, they were entitled to their permit. But again, the court made clear, if you don't own that land, or if you drill in such a fashion that you're draining from somebody else's land, that's a separate issue. We aren't deciding that today. That's for another day. Here, instead, what the EAA did is allocate the extent of these rights with all the landowners in the Edwards Aquifer area, apportioned them amongst them, all property owners, and then designated to what extent you can transfer those around. But at least initially, the permits were granted to all property owners who could demonstrate that they had historical use of the groundwater there, allocated them, and provided for them to be part and parcel of the real estate that enabled them to apply in the first instance for a permit. Finally, Your Honors, there is really here a bit of revisionist history going on, because at the time of these transfers, the way that the Meadors, the trust, and Maxwell Special Utility District conducted themselves, each of them recognized that these were property rights that they were transacting in, not personal licenses like law licenses or licenses to operate restaurants or something of the sort.
They transfer the permit via a deed?
That's right, Your Honor. But even going back further than that, take this one step at a time. The first thing that was done is creating the B.K. Edwards Water Trust. Well, we know there is no such thing under section 112.005 of the Texas Trust Code. A trust cannot be created unless there is trust property. It has to be property that you put into this thing, not some personal privilege or license or something of the sort. And the only thing put into this trust was this set of permit rights granted from the AAA. So what's the second step in the process? It's a deed that conveys these disputed EA permit rights to the trust. What's a deed in Texas? It's an instrument in writing duly executed and delivered conveying real estate. That's the Wilson versus Beck case out of the Dallas Court of Appeals with the writ refused 286 Southwest 2nd, or sorry, just Southwest 315. So the deed itself is further acknowledgement you're dealing with property, and specifically you're dealing with
The deed, or maybe I misread this somewhere, but I seem to have in the back of the mind that the deed referred to property, water rights
correct.
as transferring water rights.
Yes.
Something like that. Okay.
In other words, and then it referred to the permit itself, but it did characterize them as water rights, which we point out in our brief. Historically, when people are transacting in water rights, particularly surface water rights, they are acknowledging that they are transacting in property. Third, then, after those two transactions, after developing, creating the trust, after conveying through the deed, then these rights are leased. Again, you don't lease a law license. You don't lease things that are personal and privileges and things of that sort. What is a lease in Texas? As a matter of law, a lease is defined as a grant of an estate and land for a limited term with conditions attached.
It does not necessarily have to be an estate land. You can lease a car.
It's, in any event, it is an interest in property. It's not
Right.
simply a
Correct.
license or something of that sort. And that's the El Paso Court of Appeals in 2018, 584 Southwest 3rd, 53 at page 68. A lease can be personal property in some instances or real property. Here, it's property, Your Honor. There's no contention that this is personal property. It's that it's a privilege or something of the sort. And there's no basis for having a trust, a deed, and a lease without this being transacting in property as opposed to privileges or some mere ethereal right. The people here are transacting in property, and the proper characterization of that right under the EAA Act and under the rules promulgated by the EAA are that those are real property rights because they are pertinent to the historically irrigated land, which is the Dreamcatcher Ranch.
Did the ag easement contain language that referred to the permit itself?
It did not.
Is that fatal to your position?
Absolutely not. There were otherwise, there was an appraisal done that we point out in our briefs that delved into the value of these rights and things of that sort. But no, our point is it's merely part of the bundle of rights at the point that this conservation easement was put into place. And like any other part of the bundle of rights, it was subject to the separate conveyance prohibition. You couldn't convey air rights without violating that. You couldn't convey mineral rights without violating that. Any estate in the land that you're trying to separately convey would be prohibited absent some accommodation or exception or allowance provided by GBRT to this separate conveyance prohibition. So for those reasons, we ask that the judgment of the district court be affirmed in all respects.
Thank you, counsel. Good.
Thank you, Your Honor. I'd like to clear up a couple of points real quick. Justice Doss, with respect to the Evans case and the contract, it was a contract for the groundwater in the ground. That's the property right that got established. It's like an oil and gas lease. You are leasing the oil and gas in the ground. We're not talking about that. The Meadors own the groundwater beneath the property. Critical to this, the appraisal, the rules, all of those things are basically immaterial. You have to start with the ag easement and what it covered.
Let me stop and ask you a follow-up question based on your answers then. Opposing counsel just said just a minute ago, said, look, if we're looking at this trust, you can't create a trust and have it empty. Property's got to be put in it. And if all we have, if we recognize the right down the road, the license or the permit, whatever you want to call it, to take water, if that's not a property interest, then we have nothing in the trust.
Your Honor, I'm not a trust law expert. Okay, so I'm a little bit compromised there. But what you have to remember is that the permit right is not a property right. It is a usufruct. It is
Is the permit itself a right?
The permit itself is a right. It's a right of use.
Is it arguable then you could fund the trust by transferring a portion of the permit, a portion of the right represented by the permit, whatever that right is?
It is an interest. It is not an interest in real property, and it is not an interest in the property defined in the ag
I understand,
easement.
but transferring a portion of the permit could be considered funding the trust because
yes.
it has a right. Now, I don't want to say property, it has some type of right.
Yes, Your Honor, just like you can
What
fund a
is that?
trust with money or other personal property or other items or titles. Critical things, with respect to the appurtenance, Mr. Blank read you a portion of Rule 711.95. He left out the part where the EAA regulations provide that unrestricted groundwater may be made appurtenant to lands other than the historically irrigated land if the authority approves the transfer or amendment. And we went through the process to transfer the UGG rights at the EAA. Another provision, Section 134 of the EAA Act and Section 10.07 of the EAA Act decimate Mr. Blank's arguments. Section 134 expressly provides that a regular permit for use in irrigation, okay, may be leased all or part of those irrigation rights. If they're going to, and so that's authorized by Section 134. You have to follow the rules. That's part of the conversion rule also and the other transfer rules. But more importantly, Justice Abbott, sitting on the Supreme Court in the Bar Shop case, specifically addressed the fact that the Edwards Aquifer Act and the permitting process only affected the right to pump water from the Edwards. It did not adjudicate any property right. There were no property rights involved. Section 1.07 of the EA Act specifically expressly says, this is not a property rights issue. We are not regulating property rights. We are authorizing pumping. We are allowed to authorize pumping up to this amount. Another comment Mr. Blank made, not everybody over the Edwards owning Edwards Aquifer rights got a permit or was even entitled to apply for a permit. The Act provided a 20-year window called the historic use period that if you pumped during that period, you could apply for a permit. And if there was any water under the cap available at the end of that process of issuing permits, they would consider it. It was gone. The cap is that little. There's a valid policy reason for allowing big rights to be, pumping rights to be converted to UGG and to allow them to be transferred. But again, the critical point here is the ag easement does not address restrictions on the permit. It has one express provision regarding restriction on groundwater. That's found in Section 5 of the ag easement. And it says you may not pump surface water or groundwater from the property for use off of the property. There is absolutely nothing about transferring a pumping right that is fungible throughout the Edwards Aquifer Authority and allowing it to be pumped from your Edwards Aquifer rights on your property, not Dreamcatcher Ranch. We would ask you to reverse the lower court's decision as a matter of law. Thank you. Happy to answer any questions.
Thank you, counsel.
Thank you.
The case is submitted and you are free to go. We will be in a short recess in order to change panels. And again, thank you very